Okay. Welcome back, everybody, to our public session of the CAB, the Consumer Advisory Board meeting. This morning we heard from the Bureau's Office of Students, and this afternoon we're going to shift gears and focus on another aspect of debt collection, first hearing from Bureau staff about its recent SBREFA proposal. And following this presentation, we'll hear from two of our CAB members, Joanne Needleman and Judy Fox. Judy and Joanne will provide an overview of emerging issues in debt collection, in particular, the role of technology. And bear with me here. So, since the Consumer Advisory Board was established in 2012, issues relating to debt collection have been a feature of discussion amongst the group. Today marks a very important juncture in the Bureau's work on this topic. This will also be the first time the full CAB will have an opportunity to weigh in on this recent proposal. And so to get today's discussion started, we will hear from Kristen McPartland, Senior Counsel in the Office of Regulations, and John McNamara, Acting Assistant Director in the Markets Office. And again, after their presentation on debt collection, the debt collection SBREFA proposal, we'll turn to the CAB, have a discussion about the proposal, and discuss any themes that may have emerged. So John and Kristen, thank you so much. Please feel free to jump in.
Thank you.
Great, thank you. We'll start with a brief overview of where we are in the process, in the rulemaking process, as well as some of the high-level summary of the ideas in the outline of proposals under consideration. After that, we'll turn to John to lead a discussion on the content. So to begin, just a brief overview of the rulemaking process in general. Rulemakings typically start with an advance notice of proposed rulemaking, or an ANPR, and in fact we did so in this case, issuing an ANPR back in November of 2013. We then move on to a Small Business Regulatory Enforcement Fairness Act process, or SBREFA, as you'll hear it called, and I'll speak a little bit more in detail about the SBREFA process in a moment. That is typically followed then by a Notice of Proposed Rulemaking, or an NPRM, which is the first time that we put out the draft proposed rules themselves with draft regulatory text. After a public notice and comment period, we then move on to a final rule, and this typically followed by an implementation period. So there's an effective date included in the final rule, which allows for some period of time, again, this is typical, not always, but allows for some period of time for companies to come into compliance with the rule itself. So to talk briefly about the SBREFA process, it begins when we issue an outline, which we did in July of this year, and the outline describes in relatively plain language form what the Bureau is thinking about for the rulemaking at this time. As I mentioned, it's not draft regulatory text, and so it doesn't go into the kind of detail that draft regulatory text would. But instead, it's what is hopefully a plain language description of what our thoughts are about the current problems in the market, as well as the interventions that we are thinking about pursuing to alleviate those concerns. That's followed by a panel meeting, which we held in August of this year, where the small entity representatives come in and provide their feedback on how operationally the ideas that are under consideration might work. So we've had that feedback, and we're considering it currently. Within 60 days, we finalize a report, which doesn't typically become public until the NPRM is issued, but it does incorporate the ideas and the feedback that we've received to date. And throughout this all is the feedback period, where we meet with different stakeholders, industry, consumer advocates, groups like yourself, and solicit and receive feedback on the ideas in the proposals under consideration. So to move on to the content of the outline. It really falls into three buckets, and the first one addresses information integrity. We're aware that there are a number of concerns about the integrity of information in the debt collection system, and that can continue throughout the debt collection life cycle. As many of you know, debts may often move to one collector, go back to a creditor, be placed with another collector. Sometimes they're bought and sold through different debt buyers, so there's a bit of a debt collection life cycle that can continue on. So the Bureau is currently looking at providing some clarity around the requirements for a debt collector to possess a reasonable basis for claims of indebtedness. And those are the claims that are made typically to a consumer about the amount that is owed, that the consumer owes it, and should pay the collector at issue. Specifically, in order to collect a reasonable basis, a collector could take certain steps at 3 distinct periods of time. We're focusing on the time for before making initial claims, essentially before reaching out to the consumer, after the receipt of a consumer dispute, which doesn't happen in every case, but does of course happen in many, and before making claims in a litigation filing. And at each step, the outline describes different steps that a collector could take to make sure that they have a reasonable basis for making the claims about the debt itself. Of course, much more information is provided in the outline, and I am moving somewhat quickly throughout this so that we can get to a discussion. But I think it's important to focus on the idea that we're providing guidance about the certain steps that collectors could take, while also looking at potentially leaving some flexibility for collectors, so that if they did not take the steps that are outlined, specifically in some of the appendices, they could potentially still have a reasonable basis to make the claims under collection, but the burden of proof would shift to a collector to show that, in fact, the steps they took were sufficient to obtain that reasonable basis. Again, it's a balance between providing enough specificity to be clear for the industry, as well as hopefully allowing for some flexibility to accommodate different types of debt and the different information that may accompany it. As part of our focus on information, we're also looking at information transfer and information forwarding requirements. Information transfer looks at the passing on of information as debts move through that debt collection lifecycle. As I just spoke about, as it may move from collector to collector, from debt buyer to different collector, different debt buyer. So here we're looking at requirements related to passing on FDCPA-related information. That could be information such as a cease communication request, information about consumer disputes, or other information related to a consumer's FDCPA rights. Other federal law information, such as interest rates related to the SCRA or certain federal student loan rights, or additional information that's helpful to the collection process, like language preference or exempt income information. So these would be requirements that as the debt moves from collector back to creditor and on to subsequent collectors, that this information must accompany the account. We're also looking at information forwarding, which would occur after a debt has left the possession of a collector, but a collector may nevertheless still receive certain information about the debt. So that, for example, it could be payments submitted by the consumer, bankruptcy discharge notices, or identity theft reports, or disputes or exempt income information. And here the obligation would be to go ahead and forward that information on, even once the account has left their possession. Moving on to the second bucket, which focuses on consumer awareness. Here, we're looking at two different potential notices as well as some additional disclosures to help improve consumers' understanding both of the debt that is under collection as well as the collection process itself. The validation notice, which as many of you know, is already addressed in the FDCPA, does include certain statutory requirements about information on disputes and other information from the collector. But here, the Bureau is looking at providing an enhanced and clarified notice, which would include more information about the debt, information about the consumer's rights, and a tear-off to facilitate consumer response. Information about the debt could include additional information such as a breakdown of the amount due, including fees, interest, and charges after default, additional information about the type of debt under collection, such as credit card or student loan, brand information as applicable. And information about the consumer's rights would be additional and hopefully more plain language description of a consumer's right, particularly the right to dispute the debt, if the consumer has a question or otherwise thinks the information is incorrect. And that leads to the tear-off at the bottom of the page, which would allow consumers to more easily interact with their collectors by simply tearing off the bottom of the page, filling out a certain checkbox, and sending it back. And I'll show you in a minute an example of a model form that we've put out with the validation notice, as well as a statement of rights. That model form, of course, is still undergoing further consideration and testing, but we thought it was important to put it out so that people could see the type of information that we're thinking about including in the validation notice. The statement of rights would be an additional and new requirement to send most often with the validation notice, offering a plain language explanation of certain consumer rights. That could include the right to dispute a debt, the right to stop communications or to determine how and when those communications occur, and the right not to be harassed or abused or to have one's privacy violated, such as through a third-party disclosure of the debt. And again, although I'll go to those in a minute, these are model documents that even when issued with a rule, we anticipate would not be mandatory as for their usage, but if a collector used the model forms, then they would be sure that they had met the requirements of the rule. So just to go very quickly, and I realize that it's difficult to see this on the screen, I did want to just touch on the potential validation notice. And you can see, again, it really does divide down into these three parts, with the first third being primarily information about the debt itself, the second third being information about how to dispute the debt or other actions that a consumer can take, and the bottom third being the tear-off that a consumer could return. Similarly, we have on the screen now the potential statement of rights. And again, this is a plain language summary of some federal rights that consumers have throughout the debt collection process, including rights about communication, as well as your right to get a credit report on an annual basis, and information that certain types of assets cannot be garnished. Moving on to other disclosures that are contemplated in the proposals under consideration, we also have a potential litigation disclosure, which would be required to provide in instances when a collector represents an intent to sue, that the collection agency does intend to sue, that a court could rule against the consumer if he or she fails to defend the suit, and that additional information about litigation, as well as contacts for legal services programs, is available on the Bureau's website. So this disclosure would be given by collectors in the situation when they are saying to the consumer that they do intend to sue. We're also looking at a disclosure regarding time-barred debt collection. And here, where collectors are seeking to collect time-barred debt, they would be required to disclose in a fairly simple sentence that the collector cannot sue to recover the debt. And we are also considering an additional disclosure that if the debt is obsolete, then it cannot appear on a credit report. Obsolete we're using as a term to mean, generally speaking, older than 7 years, although we do understand there are some exceptions to that under the FCRA. But part of this time-barred debt disclosure would also be an obligation for collectors who have given the time-barred debt disclosure to then weigh the right to sue on revived debt. Of course, under some state laws, debt can be revived if a consumer makes a partial payment or acknowledges the debt in writing. But the idea here is that once a consumer has received the representation that they cannot be sued on that debt, that they would have that ongoing expectation and therefore should be able to rely on it. Likewise, subsequent collectors would be prohibited from suing on a debt for which an earlier collector had provided the time-barred debt disclosure, even if the subsequent collector evaluated the debt and felt that it was not time-barred. So once the consumer has received the time-barred debt disclosure, it would essentially attach to the debt from there on. Moving on to our third and final bucket, we'll talk a little bit about communication practices. Now, of course, there's much more detail in the outline itself, and I realize I'm moving somewhat quickly through this. But I'll just hit on a few of the high-level concepts here, the first being contact frequency. Here, we're considering a limit on contacts and attempts to contact consumers that would apply per week and per account. There would be different limits depending on whether the collector has what we call confirmed consumer contact or not. And confirmed consumer contact is the concept that the collector has reached the consumer that they believe to be the debtor, so either the debtor or the alleged debtor. Before the collector has confirmed consumer contact, the limits would be 3 contacts per line, per week, per account. So in other words, if you have 2 phone lines, an email address, and a mailing address, each one could potentially have 3 contacts, but those are subject to an overall cap of 6 attempts per week per account. So a collector would have to decide they could use perhaps 2 or 3 on one phone line, 1 or 2 attempts on another phone line, and then use the remainder on an email or a mailing address. So all subject to this overall cap of 6 attempts per week per account. Now, after confirmed consumer contact, those limits drop to 2 attempts per line per week per account, with an overall cap of 3 per week per account, and a limit of 1 live conversation per week. This goes hand in hand with addressing voicemails and leaving other messages when collectors do outreach to find consumers. And here, the Bureau is looking at permitting a certain limited content message that would not be a FDCPA communication and therefore not trigger what is commonly referred to as the mini Miranda disclosure that the communication is from a debt collector and about a debt. This limited content message would be permitted if it included only the individual debt collector's name, the consumer's name, and a toll-free method that the consumer can use to reply to the collector. It's a fairly straightforward message with just that limited information. In addition to these communication proposals under consideration, we're also looking at a number of different elements related to decedent debt, or the collection of debt for which the consumer has passed away. Here, among other interventions, we're looking at potentially a waiting period after the consumer's death for communication about collection of that debt, considering both 30 days and 60 days as a waiting period. We have a number of proposals under consideration regarding time, place, and manner of communications, which is an issue that's already addressed to some extent by the FDCPA. But here we're looking to bring clarity to a number of the issues, including some of those issues that are raised by newer technology, such as email or text messages. One aspect of this is thinking about when a communication is sent, when we are using these newer technologies for the purposes of determining whether it was an unusual or inconvenient time. As many of you know, the FDCPA says that it's presumptively convenient if a communication is sent between 8 a.m. and 9 p.m., but that can raise a question when you're not actually dialing a phone and instead sending, for instance, an email. So here we're looking at clarifying that the time at which a communication is sent would be the time at which it is generally available for the consumer. So if an email is sent at 10 a.m., it would be deemed to have been sent at a presumptively convenient time, even if the consumer didn't actually open it until, for instance, 10 p.m. that night. We also look at a variety of different aspects of presumptively inconvenient places, considering a presumption that would include facilities, medical facilities, places of worship, places of burial, grieving, or childcare facilities as presumptively inconvenient for communications with consumers, and a clarification that employer email, when a collector knows or should know that the email address does belong to the employer, would not be permitted without consent directly given to the collector. Here, again, probably many of us have the experience of logging into our work computers and seeing that there's no privacy, and we have to waive that, so we're concerned about communications going to workplace emails when a consumer may not be able to expect that that email remains unread by their employer. And finally, we have a section on consumer consent, which addresses the parameters for obtaining consent from consumers for communications, particularly those that would otherwise be restricted by the FDCPA. And these include getting direct consent, so a requirement that consent be obtained directly from a consumer by the collector, whether orally or in writing, a clear disclosure to the consumer as to what they are consenting to, and memorialization, so a requirement to memorialize consent, whether in writing by preserving the written instrument, or if oral, by recording or otherwise notating that consent in the account file. Finally, just moving on very quickly to two additional proposals that we have. One would prohibit sale or placement of debt with those who are subject to judgment or orders or unlicensed collectors where that's applicable. Of course, some, but not all states have licensing requirements. And this would prohibit those for whom the consumer resides in a state that does have a licensing requirement if the collector does not have that license. And finally, we look at record keeping, where we are looking to bring some clarity around the requirements for records that must be kept by collectors, including that a collector would be required to keep records documenting the actions it took with respect to the debt, that a collector would be required to retain those records for 3 years, and a clarification about recording calls, where a collector would be required to keep the call recordings if they in fact do record, although they would not be required to record if they don't do so currently. I just want to touch very briefly on some of the debt collection research that we've been engaged on before turning this over to John. We have been looking at the model disclosures, including the 2 disclosures forms that we've discussed and that I showed earlier. Those are both qualitative testing, and we're looking at doing some quantitative testing to help develop the model disclosures. We are engaged in a consumer survey, and the preliminary results were released as part of the SBREFA outline in August. We do expect to release those final results in the coming months. and a collector operations survey that was also released with this SBREFA outline, where we surveyed third-party debt collectors and their vendors about their current operations. We've obviously been engaging a lot of work, and we really look forward to getting your feedback through this discussion.
Thank you, Kristen. At this time, we'd like to ask for some input from the CAB members about some specific issues that we mentioned in the SBREFA. And in that spirit, we've got a number of discussion questions. The first of which is, what type of information do consumers need to know about their debt, the collection process, and their rights? What information would better help consumers recognize their debt when contacted by a debt collector, that recognize that the amount is correct, and that the person calling is indeed owed that debt or is representing the person who is owed that debt?
We will start, thank you, with Josh.
Thanks so much for all the work you've done. I want to focus, I think this is an opportunity, I think, with this SBREFA process to make sure that that we get this right. And this is a great opportunity, I think, given that this is the first time that rules have been overlaid over the debt collection industry under FDCPA, and that this is really an industry that has been Wild West for many, many years and has caused a great deal of harm to consumers and to communities. And I want to focus just on one piece, which is around substantiation of debts. And just for background, before starting my current job this year, I worked for many years at New Economy Project, and we were doing a great deal of work on this issue around third-party debt buyers. And in fact, Susan Shin, who's the senior attorney at New Economy Project, testified at the Sacramento hearings. And so we had, for many, many years, going back now about 10 years, a hotline where we took calls from low-income New Yorkers on financial justice issues, and debt collection was overwhelmingly the biggest issue that we got calls on. And it was, as I think has now been well substantiated, it was around the third-party debt buying industry that really was buying debts for pennies on the dollar based on very minimal information. And we actually then did a class action lawsuit, which we settled last year, and the CFPB did an amicus on that. And it really gave us an opportunity to learn a lot about how this industry works. And one of the things that we found out through this whole process is that really the business model is based on handing over very little information, and a lot of these purchase and sale agreements actually limit the amount of accounts for which the debt buyer can come back and request information to a pretty minimal amount. Another thing that we found out through advising borrowers going in pro se in court is that whenever they challenged these debts and the debt buyers had to come up with substantiation of the debt, almost 100% of the time, or I would say 100% of the time, the case was dismissed. We also worked closely with the New York State court system, which put out really groundbreaking rules because what was happening was that debt buyers were going into court, engaging in sewer service in many cases, so people weren't showing up in court, and then using robo-signed affidavits where they were just stating that they had personal knowledge of the debt and, in fact, having very little information about whether it was owed by that person and how much it was owed and why and so forth, and getting default judgments and then freezing people's bank accounts and garnishing wages. And we also did a study where we mapped where these default judgments were, and there was a heavy concentration of these default judgments in New York City in communities of color. So not only is it an issue that affects low-income people, but also has a disproportionate impact on communities of color. Now, again, these rules that the CFPB is working on promulgating present a really good opportunity to level the playing field in this industry so that debt collectors who are engaging in honest practices may continue to collect debts, but to ensure that this third-party debt buyer industry is not engaging in deceptive and fraudulent practices, and these were very, very widespread. And so just to cut to the chase, because I don't want to take up too much time here, there are opportunities here around the substantiation of debts that I think it's important to make sure are not missed. And we're concerned that in this first cut, that there's too much leeway being given to third-party debt buyers to decide for themselves what sort of information they're comfortable with in providing at different stages of the process. And just by way of example, New York State issued rules through the Department of Financial Services that govern what sort of information debt buyers must have and must provide to borrowers at the initial phase of the process, that go deeper than this, and also provide through a validation process that actually documents themselves have to be provided to borrowers. And also in the New York State court rules, there's a requirement that in order to obtain a default judgment, a debt buyer has to actually have in hand have reviewed documents that can substantiate the debt and the breakdown of the debt, and all sorts of information about the charge-off amount and the post-charge-off interest and fees, et cetera, full breakdown, and also provide an affidavit with a chain of title in order to get a default judgment. So there are these rules laid down in New York, and New York's not the only state. I know North Carolina has strong rules, and other states. And so I think it's really, really critical for the CFPB to build on the work that's been done in the states around this, because the state courts, for example, have seen up close and personal what happens when this information is not substantiated, and to look at the history of the debt buying industry and how they've, I guess, taken it upon themselves, maybe that's the wrong way to term it, but how they've determined their own reasonable basis, which is very, very loosely. And I think to look at providing rules that have more, a stricter basis for substantiation of debts, and so that debt buyers have to have in hand actual account level documents that can back up the debt to ensure that when they're collecting against people at different stages of the process, that money is in fact, debt is in fact owed, and how much. And one other point is the OCC issued guidance around the sale of debt by banks, and a huge portion of the debt being sold to third-party debt buyers is credit card debt from the banks, and under that guidance, the debt buyers are supposed to provide copies of account-level documents. And that I know that the CFPB is intending to address original creditors and first-party debt buyers in a separate rulemaking, but it's very hard to address one piece and not the other, and that banks also have to be held accountable about what kind of information or what these deals look like, so that when banks are selling charged off debt, that they're accountable for providing substantiation for the debts. They should not be able to sell debts into the market when there isn't sufficient backup to prove that they're owed.
Thanks, Josh.
Sorry, that was kind of long-winded, and I apologize.
No, thank you.
Chi-Chi has a comment on this question also.
So yes, thank you. Thanks very much. And this is an area of critical importance. When the CFPB first opened a rulemaking into debt collection, we were very excited because obviously not only is it the top source of complaints to the CFPB, but it had been to the FTC. And, and our experience is working with the thousands of private and legal services attorneys that represent debtors, and that, for many, many years were the primary source of enforcement with respect to the Fair Debt Collection Practices Act, and still probably file the bulk of cases under the FDCPA. We too, so I wanted to give you a little bit maybe from that perspective. We too, the SBREFA outline, there are some very good things in it. We're very pleased to see things, proposals such as requiring transfer of information and prohibiting passive collection by placing debts on a credit report without notifying the consumer. However, we too are very concerned about the substantiation requirements and believe that it is a missed opportunity to require account-level documentation before debt can be collected on. This shouldn't be a surprise to you. Last month, we sent a letter to the Bureau, signed on by several dozen consumer civil rights and advocacy groups, where the number one point was that we believe there should be account-level documentation. And if you looked at your own survey, you could see what some of the things that that consumers need because that only can be provided by this account level documentation. The single biggest source of complaints is, this is not my debt. How do you determine if it's not someone's debt without account level documentation? Having just a name, an address, and a spreadsheet, it isn't going to show whose debt it really is. 28% of your consumers said this is not my debt. 12% said it's someone else in my family's debt. This gets to the issue of who's liable on the debt. Is the consumer a co-signer versus an authorized user versus just a family member? And again, you can't get to that without account level documentation. But going back to the point of the perspective of the consumer attorneys who represent these folks, both private and legal services. We had a presentation at our annual conference. We have about 800 people at our annual conference, and about half of them are private attorneys. And we presented on this, and the comment we got back was, with respect to this substantiation issue, this may be worse than not doing anything at all. This will make it harder for them to bring cases. And it's because, over the decades of FDCPA litigation, the mantra has always been the FDCPA is a strict liability statute, okay? The consumer, the debt collector collects against the wrong consumer, the debt collector is liable. Doesn't matter that the spreadsheet had the wrong name or the wrong ID. But by introducing these standards saying you can transfer a debt with just a spreadsheet, that if there's a representation from accuracy from the creditor, the previous seller, that there are things you should look for but aren't required to. That flexibility will undermine the ability of consumers to enforce this act themselves, because you're introducing this flexibility, this reasonable procedure standard. So just to give you a little contract, my area is actually the Fair Credit Reporting Act. And under the Fair Credit Reporting Act, that is not a strict liability statute. You find an error on your credit report, you can't sue right away. You have to establish lack of reasonable procedures for maximum possible accuracy. As a result, that particular section of the FCRA, the mantra is, do not sue under that unless you are like one of the top litigators, because that's a tough case. That's a tough case. And you're going to have to pour a lot of resources into that case. So those cases don't get brought. And our concern, and I think the concern of the folks who have been bringing these cases for decades, is that by having this level of flexibility in your substantiation, that you're going to undermine all those cases, and you will actually see less self-enforcement of the FDCPA. Not to mention that,
Maybe we should let somebody else in the conversation. We'll always come back to you if you have more, okay?
Oh, okay.
I want to make sure everybody gets a word in here, okay?
Thank you.
Okay, thank you very much for your comments, Chi-Chi. Lisa?
Just to echo the piece about making sure that the debt seller substantiates the debt, I also just wanted to say that I like the ideas of the validation notice and the rights. I think those are great. The piece that I worry about a little bit is making sure that that it's like that last mile problem. How do we know that the consumer is going to read it, is going to get it, is really going to understand it? I worked, as part of my research, I worked on the predatory loan help hotline for a month, which is run by the Virginia Poverty Law Center. And I would say the number one issue there, and what was interesting about Virginia, is that storefront payday loans, for example, are legal, but not the online ones. And many of our callers were in trouble with online loans and didn't really understand that. And so that, to me, is just an example of a law, a regulation being in place that people didn't necessarily understand. And so thinking about, I don't have the answer, but thinking about a way to make those two documents as effective as they could possibly be.
Joanne?
Thank you.
Sorry. Joanne?
Yeah, thank you. Well, this may be one of the few times I might agree with some of my advocates here. I mean, the issue of substantiation is really important. And I've said this to both of you before, I'm going to say it again to the board. I think we missed a huge opportunity in SBREFA and in this process to bring in the first parties, because absolutely a consumer needs to recognize what it is that you're collecting. But third-party debt collectors that's not their information. I'm putting debt buyers for a second, because that's almost a complete and different discussion. But traditional third-party debt collectors, whether you're in medical or auto or whatever, it's not their information. So they're getting it from their clients, and mandates on their clients to provide certain information will really clear up this issue greatly. And so I agree, the more that we can provide up front, I think the better the communication's going to be, the more opportunities to understand and recognize fraud, possible recognize for resolution of debt. So I would encourage the Bureau, let's continue to have this conversation. I know it's on a separate track, but don't lose sight that at some point these two groups have to come together to figure out what's going to be the best result. Thank you.
Chris, then Judy?
Sort of pile on the substantiation piece a little bit. I'll add a little bit of color. I share a lot of the concerns that have already been raised about substantiation. Add a little bit of additional color to it, I think. And I'm not our in-house expert on this issue, but our person who was, I think I can fairly characterize her reaction to the SBREFA package as surprise. And I think in large part because there's a fairly significant difference between the enforcement actions that preceded the SBREFA package and the kind of requirements or substantiation that were included in those enforcement actions, and then the amount of flexibility or loopholes that are in this package, and the difference in the way that it's expressed, I think were surprising to us, and we'd love to talk to you more about that. A couple of additional pieces of color on this. As Josh mentioned, North Carolina passed a fairly strong law requiring substantiation in the context of debt buying and requiring a significant amount of proof, which otherwise hadn't really been required before. A couple notes with that. One is that the debt buyer said we'll never be able to bring another case in North Carolina again. They definitely have. It was a little like the subprime mortgage issue where we passed an anti-predatory lending law. The lender said we're not going to do business anymore, and then a year later there they were. But there was a series of debt buyer cases recently in Charlotte in which a judge vacated 10 judgments that had already been entered, in large part because the affidavits that were filed to support those cases were false. And in fact, we've got the audio of the judge saying, you lied to me about this. There were different reasons why those affidavits were false. In some cases, the affidavit said we're filing, we have proof that, itemized proof of the debt, and they didn't actually have it. In other cases, it was we're well aware of the business practices of the creditor, and we can fully authenticate these business records. They actually hadn't even looked at those records and didn't know about those cases. So even in a state with some strong protections, you still have this issue of affidavits being filed in certain circumstances that don't have the correct information in it. And what that requires then, though, is that this group of consumers has to get legal representation and bring these cases into court, turn their lives upside down, right, to try to be able to defend these. So the more the more flexibility, the more that we have to rest on these reasonable standards, the more it means that we then have to try to find a way to get these people into court. And for most of these folks, and other folks have brought this up as well, is that many of these cases are being filed in hopes that these people will never show up in court. And in fact, they don't. In fact, talking to one local debt attorney who handles these cases, he's actually taken the step of filing counterclaims with his appearance because he's so tired of the debt buyer dismissing the case as soon as he shows up in court that he wants to make him hang around a little while longer. And so it's the folks who don't have the wherewithal to be able to hire an attorney. They make too much money to qualify for legal aid, which in North Carolina, it is truly poverty wages to be able to get free legal assistance. In that case, these folks, they're not going to bring that case. It's actually cheaper for them just to pay the debt, which is wrong on its face. But there's plenty more, but I think those are the highlights there.
Judy had a comment, if that's okay, another one on this question?
Yeah, I'm going to have a lot of time to say things, so I just want to talk briefly about direct answer to one of your first question is what we need to know or what consumers need to know, because this is not something I'm going to talk about later. So I have a filing cabinet in my basement of my office that's full of debt collection cases, because the common experience that my clients have is the debt gets charged off. They've had some issue in their life. Maybe they'll call the original creditor and say, hey, I got a job now, I'd like to pay my debt. And the response they get is it's charged off, which leads them to believe they don't owe it anymore. So right at that level, clients or consumers need to know what charge off actually means. It doesn't mean you don't owe the debt anymore, whether it's with a statement saying we've charged this off, but you still, some indication that doesn't mean, and then what happened to it? So in my filing cabinet in the basement are all my clients who I send out a validation notice, usually with an affidavit of poverty. Look, this person's on Social Security or this person's on disability. They're never going to be able to pay you. You know, forget it. The debt collector usually just goes away. But I don't close the files. I put them in my little filing cabinet because 6 months, 12 months, 18 months later, they're going to get a second collector who's going to call, and I have to do the whole thing over and over again. It's wonderful that you're suggesting that information has to be passed along. It would also be good for the consumer to know when their debt is sold and to whom, so that when the debt collector calls and says, you know, this is XYZ, they know, okay, yeah, I remember my debt was sold to XYZ, as opposed to who are you, what are you talking about? I did a small survey, not statistically relevant because we had a low-income clients, and more than half of them didn't have a credit report, so we couldn't really look. But we ended up looking at about 75 actual credit reports. And most of the time when the consumer told me, that's not my debt, when we checked, it was that they didn't recognize the trade line. And they didn't recognize the trade line because they had no idea what was going on. So I think those things are really important in terms of what a consumer needs to know.
I think you had.
Sorry,
Dave.
Paulina?
On disclosures, they can often be limited in terms of how helpful they can be, especially for historically marginalized populations that have been marginalized from the financial services industry. So I just wanted to make that point. But and for the disclosure on collecting on time-barred debt, that's especially, a concerning piece. We'd rather see prohibiting collecting on time-barred debt. And this compounds a problem with the validation notice. It can be especially confusing for populations that might have some problem understanding this, but maybe anybody, especially if it says enclosing an amount, where you might feel like you might have to pay an amount in order to even dispute. So it's just, it just might be, there might cause some confusion with this validation notice, and I just wanted to point that out.
Can I toss in 2 cents briefly? Thank you. I love the notion of having, I love Paulina's comments. Conversely, I was also thinking, love the notion of having something that attaches to the debt, tagging it, catching it in the wild, clipping a tag on it, tracking its life cycle. What I was wondering about, because I think that's great for the consumer, and I'm totally hearing from Joanne, that's really actually great for third party, and it crossed my mind, like, as long as you're going to have third party debt buyers, it's good for them too, to know what it is that they've got. Is it valid? Is it not valid? But I'm wondering how you're actually going to be able to create a system that really truly tracks. Because absent that, it's, stay tuned. Okay, right. But that was the next thought, but just want to say, kudos. I like that, the concept, and if we could build on that concept, that would
Thank
be
you.
really helpful.
The next question, we heard a lot of feedback about the amount and the quality of information that might be given to debt collectors and debt buyers, but we'd like to hear from you if you have thoughts on whether the amount and/or quality of data that moves, is there a difference between contingency collectors who are collecting on behalf of another creditor and between debt buyers in terms of that amount of data or quality of data?
Joanne?
Sorry. I don't want to steal the conversation here. I think it's really about length, how far along you are with the debt. I mean, if it's an 8-year-old debt, the quality of information you're going to have is going to be significantly less than if it was 6 months to a year. So I don't necessarily know if it's a debt buyer third-party issue as much as it's a timing issue.
Interesting. Other comments on that question? Sorry, Josh?
There are certainly difficulties as the debt gets older in maintaining a file, but as a basic concept, there's basic account level documentation that should travel with the debt when it's sold, and the business model should not be based upon having very little information and only digging back into the files when it's challenged by a lawyer. As Chris was saying, it's a very small percentage of people that actually challenge them, and the model is built on just trying to push all of this stuff through. So we certainly believe that regardless of whether it's a third-party collector or a third-party debt buyer, there's that basic level of account-level documentation that should travel with the debt.
I did a study several years ago, looked at thousands. Now, these were all cases that had gone into litigation. So that might make a difference in my results, but I looked at thousands and thousands of files all throughout Indiana. And I would say that there was substantially more documentation on a contingency collection than there was on the third-party debt buyer. In fact, it was rare when they were a contingency lawyer for them not to have had the documentation in, and it was rare when they weren't for them to have had documentation.
Chris?
Yeah, I think following up on that, I think that's fairly true, and I think most of the worst cases we're definitely seeing are in the debt buying industry. I think there's also obviously a real question of incentives as well, and I think when you're buying these debts at pennies on the dollar, and the way you make money is by collecting on as many of them as possible. You've got this very incomplete information, but then also sort of what do you do with it, right? I mean, there were at least 10 guys named Chris Kukla who were all born in the Chicago suburbs around the same time that I was born, and there's one guy who keeps Facebook friending all of us because he wants to know who we all are. It's great. But it'd be very easy if you had a spreadsheet that said, Chris Kukla, who lived in, Wheaton. Well, I live close enough to Wheaton. That makes sense. We'll go ahead and push this through and hope that he doesn't hire an attorney to prove that he didn't actually live in Wheaton because, I lived close enough. If your incentive is that, if I can make money by doing this, I'll do that. There's not only the issue of how incomplete is the information, which is fairly incomplete, but then also, is that information so incomplete that it makes it easier for you to be able to push the debt onto somebody who actually doesn't owe it?
Thank you. The next question, how well do creditors monitor the behaviors of their debt collectors and the buyers of their debt to make sure that the consumers are treated with dignity and respect?
Joanne?
Well, you know.
I know very little, but I know something. A lot. I mean, you might, representing clients who go through audits, I would say 4 or 5 years ago, clients would come in, and I'm talking major financial institutions, not the dentist or the HVAC guy, but major financial institutions, whether it be credit card, auto, student loan, would come in to, whether it be an agency or a law firm, once a year. Certainly, when the FTC started taking notice of debt collection and with the opening of the doors of the CFPB, that started becoming twice a year, once a quarter. I have clients who represent major financial institutions who come in once a month. The audits that my clients see from original creditors is massive. I think data that we submitted in the AMPR when I was president of NARCA, which is National Creditors Bar Association, is that compliance costs, and those are costs of dealing with audits and having systems in place, had gone up 329%. So there's a significant amount of money that's being spent to this issue. And I will tell you that creditors, the consumer experience, is the #1 priority when they go into agencies and law firms about how we're treating consumers. More so, I would say, than recoveries, because it all used to be about, what was your liquidation rate. Now it's how you're treating the consumers, the complaint logs that you have to submit. All calls are now recorded. So there is this effort, incredible effort, and money and time being spent into trying to rectify what we all know over the years has not been a good experience, but that has, I can certainly report that that has changed.
I think it, sorry. Chi-Chi, did I see your hand? I think it depends on the creditor. I've heard, hideously abusive recordings in the mortgage servicing context, and first-party collections on behalf of some very large entities. And what I've listened to in the recording mirrors what other people for whom I don't have recordings have reported has been their experience. So I'm deeply concerned that it's not actually translating through in all instances, and that customer experience just may vary massively by sector, and that perhaps that's one way of trying to make sense out of, when it's working, when is supervision good, when is training good, when is there good oversight versus the exact opposite happening. Chi-Chi?
So to your point about depending on sector, I just, I wanted to bring up that there are other statutory or regulatory schemes that require the original creditor to supervise the collector, most importantly being the new IRS rules governing collection of nonprofit hospital debt, and that will make the hospital responsible. And, I don't have any experiential information to give you because those recently took effect, but I think it's important that there be some interplay between the two, and if there's violation of one, there'd be violation of the FDCPA. Chris's point reminded me of a couple things. Number one, the issue of matching consumers to the right debt or the right account is a big one. In credit reporting as well, and here it's even worse because sometimes you don't have the Social Security number, which is the key piece of information. And matching criteria has got to be critical in this as well. And on credit reporting, just to remind folks that all of these actors, both the original creditor and the debt buyers and debt collectors, also have obligations when they're reporting to the credit reporting agencies under the Fair Credit Reporting Act, furnisher accuracy and integrity guidelines, which they themselves require substantiation of a debt so that if there's a dispute, a direct dispute to the furnisher, that furnisher can substantiate it. And so they already are under these obligations. And so it shouldn't be hard, for example, to Joanna's point, to require the the original creditors to provide this information because they should have it in the first place when they were reporting it so they could respond to credit reporting disputes. And I'll stop. Thank you.
Chris, you had a question?
A couple comments here, and it builds a little bit on what we were saying before, but I think what everyone said is correct. I think it does, it is dependent on, there are some folks who take this more seriously than others. I think at least our experience has been is that once it's offloaded to a debt buyer, sort of all bets are off for a couple of reasons. I mean, one is it's a pool of debt that you haven't been able to collect on previously. You want to get rid of it, and you just want to make a little bit of money on it. And then you can point fingers at the debt buyer and say, well, they're the ones who are doing it. I think some creditors are obviously taking that pretty seriously. Some have stopped outright and selling their debts to debt buyers, but that has not at all stopped the industry, and there are plenty of creditors who are selling that on. I think this fits into a lot of these questions, but I think the reason I made the comment about the difference between the settlements and the SBREFA package is that the settlements, really establish sort of a baseline of proof, right? And I think, like it or not, it really gave a clear indication of this is what you got to show if you're gonna haul someone into court, and this is what you're gonna have to show them. You're gonna have to prove that you've got, and I think that that's pretty important, and I think it makes it more difficult for consumers to figure out what's going on if there's lots of different ways that different collectors or different debt buyers can prove that information, and you think, well, you should have to prove this. Well, actually, I don't. I can prove it this way instead. It creates a lot of difficulty, but also, debt buyers can hide behind that. And so when you ask about, being treated with dignity and respect, if you're still able to play with the information, if you're still able to kind of do these things and find loopholes and ways to do this, then you've got actors out there who they're going to do that. It reminds me of there was a law firm in North Carolina that was litigating these debt cases, and it turns out that they had a series of LLCs that were debt buyers, and funny enough, they were all named after bottom-feeding fish. They knew what they were doing. They knew what they were getting into, and they were particularly aggressive in that state, and that's even with pretty strong protections. So I think it shows how imperative it is to have a strong baseline of protections in this industry.
Thank you. I think we have time for one more question. And have you observed any new approaches to collections that struck you as more consumer-friendly, or perhaps if not more consumer-friendly, maybe less adversarial than the traditional collection approaches that you've experienced? And if so, what are they?
Joanne? Please, we love hearing from you.
Yeah,
Come on.
No, I'm sure you know. But yeah, I think I had told you about this. There's a series of meetings that go across the country with collection professionals, and we get together and we call them compliance forums. And we just get together and talk about issues and compliance and new techniques and things like that. So one of them is chat. I'd asked a question, I always ask the question when I go to these meetings, who does chat? And finally, in one meeting, somebody raised their hand. And, to me, I think Amazon is I'm sorry, Max. I think Amazon is just like the coolest thing. And I think that the way that they handle your purchasing, your returns, is wonderful. And I don't know if anybody's ever returned anything on Amazon. It's the easiest thing. You log on, you get a little pop-up thing, you have a conversation, I get a little code, I return it, and then when I'm done, I get an email. It just has my whole conversation. So this one particular agency said that they have chat, and they have spent a lot of resources in training. There's only 3 people in the entire agency. I think there's probably over 200 people in the agent collectors that they have, but only 3 people have gone through the process and are doing the training. They are doing chat, and it is working out wonderfully. They can have a conversation every time they're done. They get an email of the conversation. They keep a record. So we're going to talk about this a little bit more, but it's the industry has been very slow to adopt technology. And we'll talk about that. But here's one example where I think technology could really, especially with outreach to consumers, where it really works.
Thank you. Arian, did you have a comment?
Yeah, largely by absence of a comment. I kind of feel like this question is one I should have like a long answer to, given that my day-to-day job is to find kind of next-gen, technologically motivated solutions that are more consumer-friendly. The only one that I know of, really, you're already aware of as well, True Accord, which is trying a number of new things kind of in the chat vein and using machine learning and using kind of multimodal, more informal ways of communicating without humans. But I think it's worth noting the dearth of solutions here, and that's unfortunate.
Thank you.
I don't have a good example, but I do have kind of a question. Sorry, I see Brent. One quickie just about, I'm wondering whether or not the information that's housed within the first-party creditor is not the platform from which information is being drawn, and I bet Joanne you may know this, is not the platform being used to shoot information over to the third-party debt buyer. And so if you've got stuff operating off of 2 different platforms, you by definition have established a structural problem that has to be, should be examined, understood, examined, and addressed. Okay, and I see Joanne nodding her head, so that sounds like that's correct. Oh, pardon. Okay, awesome. Brian.
Just to quickly pile on to Joanne's comment, it's the same thing as marketing, same thing as service. A digital collection experience is going to reach many consumers in a more friendly manner, and it will actually reach some consumers that won't talk to you over the phone, that don't like to talk over the phone. They're just, right, people have preferred modes of communication, and a digital experience can be very, very good for accommodating those consumers.
Okay, great. Okay, can we make last one, Jim?
Thank you. So just a comment that, this is very, very, very early stage, so I think it'd be difficult to implement this soon, but when we talk about the challenge of having a common record, and especially a record that could follow one around, the person that, being collected upon and the people doing the collecting, the thing that popped in my mind, again, very early stage, was blockchain now. So, which is that's what it does. You have a ledger assigned to a record, and everybody that's on it has the same copy of that record. Now, the challenge of blockchain at this stage is like, the same problem you have with the first people who got a fax machine or a walkie-talkie, is that until the other party has one, they don't do any good. But it's likely to be coming, and essentially that day, there will be some first application. So, it could be worth looking into.
Great, thank you.
John, Kristen, I'm sorry that I think we have to wrap up. Appreciate the work that you're doing tremendously. Thank you for taking the time to come and present to us and get feedback from us, and hope that we can be of further service in your process.
Great, thanks for having us.
Thank you so much. We're going to shift to a presentation from a couple of our CAB members, a trends and theme presentation. and let me go ahead and introduce them formally. This Trends in Theme issue is going to be more on debt collection, but particularly on the role of technology and the need for modernization in the debt collection space. Judith Fox is a clinical professor of law at the Notre Dame Law School, where she teaches and practices consumer law. She joined the faculty in 1997 and teaches courses in consumer law and negotiation. She also directs the Economic Justice Project, a low-income clinic specializing in foreclosure and debt collection defense. She's a member of the Indiana Mortgage Foreclosure Task Force and co-chairs the AALS Clinical Section Standing Committee on Lawyering in the Public Interest. Before law school, she was a bank manager and a loan officer, very diverse experiences. Ms. Fox has authored a number of publications, and those publications also address issues of foreclosure and debt collection. To her left is Joanne Needleman, a member of the law firm Clark Hill PLC, where she leads the Consumer Financial Services Regulatory and Compliance Practice Group. Joanne has extensive litigation experience in state and federal courts, successfully defending creditors against claims brought under the Federal Fair Debt Collection Practices Act, Fair Credit Reporting Act, and the Telephone Consumer Protection Act, as well as the state consumer protection statutes. She provides regulatory counsel and consultation to numerous financial institutions throughout the country. Joanne is the immediate past president of the National Creditors Bar Association, or NARCA. Thank you both so much for putting together this presentation. Please take it away.
Thank you for having us.
And we're hoping this is going to be a bit unusual in that we're going to be having a conversation as opposed to a
We found
formal.
we found out we get along really well, so that's why. We agree more than we disagree, which is good, which is good. And we'll try not to be repetitive, and we really certainly want your comments as we talk through these issues. So again, thanks for giving us the opportunity.
And we're trying to figure out how to change the
Yeah.
slide here, which is
Oh,
our.
I got it. So, we're talking a lot about technology, and in this slide, I really made a mistake here. It should be technology, parentheses, the lack thereof.
Yeah.
There really is very little technology going on in the debt collection space. And why is that? Well, several reasons. As we all know, and just for brief background, I will tell you, Mr. Director Cordray is not here, but I'll say to CFPB staff, industry's really happy that you're thinking about regulations, because this has been an industry that has been, I wouldn't say unregulated, we have been regulated. There's lots of, we have state regulators, and there's been numerous court cases that have set policy about how we do our business, how the industry does their business. But for some reason in 1977, when they enacted the FDCPA, Congress had a beef with the FTC. For what reason, I don't know. And they specifically did not give them rulemaking authority. They gave them some enforcement authority, but no rulemaking authority. And, you look at other agencies, I mean, this was a critical mistake. So thankfully, when the CFPB came around, that FDCPA rulemaking authority was transferred over to the Bureau. So I think we're obviously heading in the right direction. But we have a statute that's from 1977. Think about 1977. We had no faxes, we had no phones, we had...
Well, as I was joking, we were talking about this, in 1977, my grandmother still had a party line.
Right.
And I'm sure some of the young folks sitting here don't even know what that is.
Exactly. Right. So, I mean, there was just no conception of how people talk to one another. So we're really dealing in the dark ages here. And as you can imagine, the Act itself does not address technology, alternative ways to communicate, other than a letter or a phone call. And in this day and age, nobody really sends, nobody really sends letters anymore. If they do, who knows if they're reading them. And I have a landline, and the only reason that I have a landline is because I want to get my Comcast triple play so I can have my internet and my cable, but I never use my landline. I use my cell phone, and cell phones are particularly not addressed in the Act. And as I said, we have all these changing modes of communication. So the question has always been, as the Act is developed, and certainly as we're walking through these rules, what is the appropriate ways to communicate with consumers? And I think that the outline makes some interesting overarching themes, and I think some important themes, and that the intent of some of the proposals is the control to the consumer of the rhythm of how the communication is going to be made, and how the consumer can control how they want to communicate with debt collectors. And I think that's a really important discussion to have. I think it works both ways, but I think that is the important discussion. But I will say about the outline, well, it talks about emails and it talks about text. there really is no regulatory scheme on how to do that. And an industry that has been really fraught with, a lot of litigation and a lot of potential liability, we are really looking for, what's going to be the regulatory scheme to do, to move us into the 21st
Right,
century.
and one of the things we talked about a lot is, just the very notion of what's a communication and what's a writing, is a text, is a Twitter, is a,
Right.
there'll still be some that we haven't thought of that will come out in 5 or 6 years. And currently, the state of law is made on a case-by-case basis,
Right.
jurisdiction by jurisdiction, and a lot of conflicts. So, there is understandable trepidation by the industry to jump into technology, not quite knowing what's going to happen in this state or this federal court or this, related to that. So there really needs to be some guidance here, and some guidance that isn't already obsolete about how you define these kinds of communications. So.
I agree. I mean, I meet with clients all the time who are looking at technology, looking at texting, looking at emails, and I have to be very conservative in my approach a lot of times because I say to them, do you want to be the test case for class action? Do you, look what the potential exposure is? With all the money that they're spending on compliance, that is a real consideration. Just some data from DBA International, which is the largest association of debt buyers. When they did a survey in 2003, I believe, leading up to the ANPR, that 68% of their responders indicated they don't use technology, as I said, because of uncertainty as to compliance with applicable laws. So it is a big issue. So here's just a data from ACA International, which is the American Collectors Association. We submitted this in the SBREFA, some of our comments in SBREFA. As you can see, letters and telephone calls are almost 100% of how the industry communicates with consumers. Email is at 31.7%, and I will tell you that is because if there is there's some talk with the consumer and they say, yes, you can email me, it's getting better and better, but there has to be that letter and phone call first to get to that point. Text is minimal, and I think that the issue of text is addressed in the SBREFA because of usage issues and what it could potentially cost to the consumer, so that's a big issue. It's not been embraced by the industry whatsoever at this point, I should say. In preparing for SBREFA and some of the folks that I worked with, we talked a lot about technology in our preparation, and I was always interested to know, how is technology being used today? And a lot of companies are developing portals. And they're using portals in a lot of different ways. Obviously, I think one of the best ways to use a portal would be to dispute. So a consumer could come on, explicitly say what the dispute is. You have a record of it. It helps keep the dispute logs. It could also show, if the dispute has been resolved. I mean, I think the CFPB has used technology for their dispute portal, and it's doing very well. But about 40% of the, at least ACA members, have portals. 60% do not. I think that is a factor of the size of the agency and the amount of resources that they want to use.
And then related to that then is to find ways, and Jim just mentioned maybe one possible way, but to find ways of when you have that portal, you have that trove of information. If this debt gets sold, that information can easily go with it.
Exactly.
And right now we have various platforms and technologies that can't speak to each other, which makes the transfer of information incredibly difficult.
Exactly. I will tell you some industry, some members of ACA and industry participants are using portals for payments, obviously. There's one agency who was actually a SIR talked about the portal that he used for his agency. He just has a portal, and the consumer can log on once a week, once a month, once a year, any payment that they want to make, assuming that there's no dispute, assuming that they acknowledge the debt, they can make a payment. They make their own payment terms. They want to pay $5, they want to pay $100, but he has that capability, and he said it has worked very, very well. So there are people thinking of ways of doing differently, but there's so much trepidation, and hopefully we can encourage more of it. I will just note that the Bureau has not been very encouraging for technology. Obviously, in the student loan servicing best practices, that was a big issue. There are just a couple quotes from the Bureau at certain field hearings acknowledging that communication is, technology is important. It's just, we're using technology to get a loan. We're using technology to buy a car. We're using technology for mortgages. Somehow, the minute the loan goes bad, the technology somehow is going away. I'm not quite sure why.
So this is kind of my laundry list of just,
I'm
you got
sorry.
it. Just my laundry list of issues. Not meaning to be any solutions, but things that, consumers have thought of and consumer groups have thought of and things we're concerned about. So, well, we really acknowledge that one of the major issues with the act is to bring it into the 20th century, not the 21st, but is modernization. We also know that it comes with a whole lot of concerns. The Bureau has acknowledged the fact that many people's emails are their work emails, and clearly you don't own your work email, and that's a privacy issue. But from the standpoint of the industry, it might not always be obvious, but also people use each other's emails. It creates that kind of concern with kind of data banking, data trolling, and all those words that I don't know. Who can get access to that? What things get triggered by an email to my account about a debt? Does that cause me problems somewhere else? Do I start getting other kinds of spam? That kind of information. Clearly, while most of my clients use cell phones, their lives are their cell phones, my students, I've always advised my students if they want to reach our client, they need to do it in the first 2 weeks of the month, because the prepaid money runs out in the last 2 weeks of the month, and then we start over. And there's a real concern of calls to cell phones, and those things costing money, or remotely accessed, checks and those kinds of things automatically going to accounts, causing problems. And then the flip side of technology. This will probably go away at some point in time. But right now, if everything is tech-based, if all your error resolution solutions are tech-based, you leave out a lot of my clients. A lot of my clients still don't have internet access. I've talked about my mother numerous times. My mother can no longer access her bank account, essentially, because she refuses to even pick up a computer. So now I have to check her bank, because she can only get now things online. She still goes to the bank and withdraws all her money and walks around with cash. There are elderly people like that who won't ever access things that way. And then the other problem we have is accountability on both sides of the issue, right? How in this medium does the consumer know that this collector is legitimate? We've all had the emails from the Saudi prince and, whatever. And how do the collectors know that this is who they say they are in mediums where pretending to be somebody else is almost the norm? We're not really trying to raise solutions here, is to just bring up all of the complicated problems we see with going into technology area, even though we think this is where we have to go.
I mean, I would just add to that, and I think that's where the regulatory scheme really is helpful, because, when you set the best practices and you say this is the right way to do it, it'll help consumers identify that when they do get that email or that text, it is coming from a fraudster. There is, admittedly, I mean, a year ago, there were some of us, we were at an FTC symposium down in Texas, and they were raising the issue of fraudsters and debt collection. I was like, I don't have any idea what you're talking about. Well, within that last year, it's become well aware. There is this, I don't know whether it's coming from another country, but there is a lot of electronic fraud information in the debt collection space that we're really starting to see. So delineating what's good and what's bad is going to be very, very helpful for both legitimate debt collectors and consumers.
And again, it goes back to that issue of a consumer knowing what debt is being collected, and sort of having some chain of information of who has it. That way, when the guy calls with the fake payday loan and says, you have to pay us back immediately, you have some sense that, and that's one of the most common ones that we're seeing, is the fake payday loan. They have some sense of, wait, I don't have a payday loan with you.
Right.
So
record keeping.
yeah, and we talked a lot about this, so we're not going to go into this. I think it's fair to say we both share the concerns that there needs to be a way to substantiate the debt and keep the train of title and all of those things, but that the debt collector can only pass on what they're given. And if you don't focus on requiring them to be given information, they
From the
can't
beginning.
pass information on.
Right.
And so, I think, again, we've talked a lot about it, and we can maybe in the discussion, so we won't spend a lot of time.
And Maeva, getting back to your point from before and transfer of information, I think conceptually, I think we can all agree on that. I think facilitating and executing on that is going to be tremendous because, again, you have so many different players. Bank of America system is different than Discovery system, which is different than somebody else. How are all these institutions and companies going to be able to talk to each other? I know there's been discussions about having one, almost like an MLS type of, when mortgages are transferred, I mean, they're in one.
Yeah, and all I
that
can-
creates problems too.
All I
but-
can remember is mirrors, and so I'm not sure.
Right, well, that's true too. But I mean, it is such a broad discussion, and it's going to require an infrastructure that we absolutely do not have now.
Right.
And that's how we have to figure out what's that infrastructure going to look like.
Right.
And maybe, I never even thought about blockchain, but maybe that's the step in the right direction.
Yeah. So we wanted to move on to talk about, actually, I put down 2 areas that I think are going to be sort of growing concern. I have to say that Chi-Chi reminded me of a third yesterday, so I will just throw that one out to begin with. But I think just sort of as a introduction, it's been mentioned before, but, debt collection continues, and I took this from your wonderful report before I knew you were going to be sharing that with everybody. Debt collection is one of the largest areas of complaints, both for CFPB and FTC. I think if you check most attorneys general's websites, you'll find that's the same. But when you look at sort of the aggregation of mortgage and student loans and debt collection, you see that together they are huge. So we really wanted to talk a little bit about student loans, mortgage, and then the third that I'm just going to throw out there is recently the IRS has authorized third-party debt collection of IRS debts, and some of the same issues that we're going to be facing with student loans, we're going to be facing with the IRS debt in that consumers have certain rights, like offer and compromise, or stating that, well, for offer and compromise, they won't be able to do in this system, but things like being able to fill out a form to say they're currently uncollectible, which there's, questions about will debt collectors be informing people of that and letting them know where they can find these forms. So let's go on to, so some of the reasons we picked these 2 areas, first of all, we see them as growing concerns, but also they're frighteningly similar, right? So in both the areas of the mortgage and the student loan, we all know that the paperwork is very confusing. Tracking who owns your debt and how much your debt is very confusing. There are different options to cure your debt and solve the problem, and this is where I said it becomes similar to this IRS debt, but there is not a comprehensive scheme about how to do that, and there's concerns that when someone's in debt collection, is that debt collector motivated to say to you, hey, you can go into income-based repayment, or, hey, wait, you should be able to get a loan mod here, or something. Especially, again, we're thinking of this future-driven, which would be post-HAMP, which is expiring at the end of this year. There's a lack of adequate paper trail, we all know that, and then there has been massive servicer misconduct and abuse that's been well documented. I don't need to talk about it, but that's why we see these 2 as big areas of concern. And taking from, and I don't think I cited you guys, but this is coming from the CFPB report, there was a 75% increase in complaints about student loan collection in the period between June and August of 2015 to June and August of 2016. The Department of Education is reporting more than 8 million federal loans in default. You can see this information. And as we talked about earlier today, it's very difficult to get information about your loan. It's very hard to get information about the identity of your lender, and you can often have multiple loans with multiple players. In other words, you get a loan every semester. You take a semester off, so you might have 3 loans with this lender and 2 loans with this lender. I remember when my son graduated, and now it's been 10 years ago, just trying to figure out who all his loans were with was massively confusing. The kinds of complaints that come in on student loans, again, thanks to CFPB for this research, most of them relate to not being able to get income-based repayment. And that's really where we have a concern about these as they go into collection. Because what all of the research is showing is that the servicers, and then again, some of these do end up actually with debt collectors, especially the state ones, but don't pass on that information, or don't know that information, or don't quite know how to do it correctly. And again, we had the same issue with mortgages, right? Where you have some servicers with a lot of information, some servicers bad information. They give incorrect information. I've had many clients being told that they can't get income-based repayment, or incorrectly.
Yeah, I mean, I think that's really, excuse me, I think that's really a training issue. And
Right.
it's a real problem on both sides. First of all, it's a complicated process that needs to be simplified with, I think the Bureau has identified that. You're looking at servicers, there's high turnover rate in servicers. You go through a period of training for whether it be a call center or whomever, and then you're coming back 4 months later. It's a whole new group of people again. So there's a lot that needs to be developed in the income-driven repayment, which I think is really the answer to all of this. But again, it's an implementation problem, as I see it.
Can I ask a quick clarifying question? Hi.
Sure, yeah.
Just when you talk about the number of complaints increasing, I'm just wondering, can you give us a sense of the magnitude of the problem? So what was what was the number of complaints in 2015, and then?
I should note, there were some changes in the methodology of the kinds of complaints that were submitted, so that would need to be taken into account as you think about these numbers, so.
What kind of numbers are we talking about in terms of?
It's actually in the materials that we were given before for these
in the
meetings.
binder?
It's in the binder.
Okay.
Yeah.
Great.
I don't off the top of my head remember what the numbers were. I think the point we wanted to make, though, is that they have been steadily increasing. And that's why we're seeing this as sort of the looming problem going forward when it comes to debt collection. We can go kind of quickly.
My own perspective on that is, my sense is that some of the changes in complaint volumes at this point in time would be attributable to increasing awareness of the CFPB brand. It doesn't necessarily indicate that there has been a deterioration in practices in some particular sector. It may mean that, but it doesn't necessarily mean that at all. We are seeing certain spikes in trends in complaints, and we can identify problems from those. But I would caution whether an increase in complaints in a particular market necessarily means that things are getting worse there, as opposed to just we're hearing more about what is already problematic. So.
And I may have misspoken. What I was saying is there's been an increase in delinquencies, which may or may not. Yeah, exactly. That's a different thing. There has been an increase in delinquencies going forward, too, as well. So, and this is just for those who might not understand with the student loan issues, that there are ways that you can cure a default. And then after you do that, if you rehabilitate the loan, it goes to a servicer, and you might be able to go into income-driven repayment. And part of the concerns are that people aren't either being told this, or mid-process, maybe it gets transferred or something. And again, with the similarities to mortgages, do you get transferred and start all over? That kind of thing happening is things we're concerned about. So in other words, if it gets transferred to a debt collector and you're halfway through this process, have you lost everything you did? Do they even know that they're supposed to continue? Do you even have those options, or at that point it's collection or nothing? So.
Can I ask a
Yeah.
question? Just and maybe it's more of a comment. Either way, I apologize, but wondering about just the training issue. So Jan, you mentioned training issue. I absolutely get that. Then I'm wondering about. This section of our day is also to talk about technology in this field. So, and some of that technology could be made available for become a required part of training or triaging.
I agree.
We have, on the mortgage side of the house, we have dealt with folks in one department, because department names keep changing, who tell us that they cannot see a variety of screens, much less can they input changes into a client's file given the level of approval, like calling the CIA. do you have security clearance to make this change for my client and their debt? You know, and so I'm thinking about the CFPB as prudential regulator, seeing how operations are done and figuring out how they could be done better for the collections piece. And I'm wondering if you have examples of good triaging, innovations in triaging software or approaches to it.
Well, there's a couple things going on here, especially from the student loan servicing, mortgage servicing, original creditor. A lot of, and you say, do I get the clearance? That's client-driven. So there's got to be some sort of connection between the servicer and the client to agree on what accesses they can have. That
I'm talking about first-party creditors.
Right. Well, that's, but a lot of first parties use servicers. So they may not necessarily be a debt collector because they're just servicing a loan. It may not be in default, but there's not always an equal playing field between the servicer and the creditor. So that's where you get into that problem. Technology-wise, it's hard because, again, you have privacy issues, and that's the biggest issue. That's the biggest concern. And I think in some ways, aside from not a lot of clarity in the regulations, is the privacy issues. Cybersecurity, you're dealing with, Will shaking his head. There's a lot of constraints on what we can do. I think that the industry's trying to work through them, but also, terrified of potential liability if we get it wrong. So, interesting thought. I don't have an answer to that question.
And I think that the tech people really need to, because again, this is something we saw in the mortgage world, as you well know, right? Is that it wasn't even just if you were in default, you had to talk to different people. But if you were in default and wanted option A, you have to talk to this group of people. And if you want option B, you have to talk to this group of people. And people in group A don't talk to people in group B. And when we're talking, we're in some sense talking about first parties, but we are seeing more and more student loans being sold off to third parties, or at least contingency collection kind of things. And that's really what, could be an increasing problem. And they tend to be state issues, but.
One last question, and then Kathleen, sorry, didn't
Yeah,
mean
no, you're
to
fine.
take a turn at hogging here, but, so I think I'm hearing, and maybe it's a question also for both Joanne and Will, so is it an externalization of the collections process that's creating a regulatory privacy problem? Is that what I'm hearing? Because it's not something, don't have in-house collections pursuing something, so whatever coverage you have as to liability, I'm trying to understand what the privacy issue is in this collection space a tiny bit more. When we're talking to people who are contractors for an entity, for the first-party creditor versus in-house staff for?
I think it's a problem on both ends. I'm sorry, Will, go ahead.
No, it is. It frankly cuts across, and the data security piece around what, kind of the requirements and what we need to do to safeguard what's going and how we treat that data is, frankly, is a concern and something that we've had to work through. That's clearly a challenge in how we deal with it, and an obligation that obviously we have.
I think this could be a little bit of a red herring when we're talking about student loans, because my understanding, and I wish Seth was still here, is that as soon as the loans go into default, they're pulled from the servicer and they go back to DOE, and then they go into collections. So unlike in the mortgage context where the servicer has a relationship all the way through with the federal loans, they are the servicer who is doing the collection of the monthly payments doesn't have the files anymore once they go into default. And in which case, and maybe even.
That's the federal ones, but we're talking broader than that.
Yeah, I realize that, but the great bulk of student loans are federal. I'm only talking about federal, so I think it's a red herring for that. But if indeed DOE is putting in place this platform where it's sort of, one place that borrowers will go to get information, and it will supposedly streamline things, there's no reason, I can't imagine that they can't tie on the collections piece to that as well, on the federal level, and in terms of technology.
Yeah, no.
You would think.
And so then, moving on to the foreclosure issues, think about 3 to 5 years ago, the buying of deficiency judgments and non-performing loans was one of the hottest markets out there. That may have died down a bit, but you figure that these people have bought these now, and now they're going to start trying to collect them. I know that I have seen a big uptick in the collections on deficiencies. Now, deficiencies aren't available everywhere. Interestingly, though, people don't know this. A debt collector that I work with often, who I have a great deal of respect for, told me he will not accept a deficiency mortgage judgment for collection because, and I quote, "the number I'm being asked to collect bears no resemblance to what's actually owed." And I think part of the reason for that is that in many, many states, there's no actual record of what's owed. So some states, after you get a mortgage foreclosure and there's a sale, if there's a deficiency judgment, you go back to the court and confirm it. But in many states like mine, the sheriffs do the sales. You know, they have a sale price, there's a judgment price. They never get reconciled together, so the consumer doesn't know what's owed. And in my experience dealing with loan servicers, there seems to be an extreme lack of understanding that once a judgment is a judgment, you don't get to keep adding things to it. So there'll be a judgment amount from the court, you know, and then they'll decide to wait 2 years to sell the property, and suddenly they've added inspection fees and maintenance. I was mentioned yesterday that I actually my client got a letter yesterday from a house that was foreclosed on 6 years ago that is sold, and he's actually moved into a new house, that the servicer of the loan that actually is now owned by the bank was sending him a bill for maintenance. And you know, the house was foreclosed on 6 years ago. So there's this ongoing lack of understanding on these things. There's a lot of confusion in the market between judicial and non-judicial, when you can get deficiencies, when you can't. Many people were told that not to worry about deficiencies, and told by lawyers representing consumers, oh, don't worry about deficiency judgments, nobody ever collects them, and agreed to things where there are deficiencies where now people are collecting them. And many people never understood. There were some short sales done for periods of time there where there actually are deficiencies attached to them, and consumers didn't realize that. And so I think there's a whole area out there where there's an awful lot of confusion on that is going to start to rear its ugly head, that has a lot of the problems that we've been talking about. Okay.
Yeah. All right, so we just want to talk about a couple other issues of concern that we see that are tied in both to the industry as a whole and some of the outline of proposals.
And this is probably where we disagree the most.
Not really.
Well,
Yeah, some.
yeah.
That's true. Yeah, we had our hottest conversation. That is true.
So, from the standpoint of consumers and me personally, I think it's very, very important when we're doing rulemaking to look at deceptive litigation practices. I know that many in the industry feel that this is beyond the scope, and I'm going to let Joanne speak for herself on this, but I do think that because that's becoming kind of a preferred method of collecting, that this needs to be really looked at. And some of the practices that I've seen that I think are deceptive, obviously robo-signing, I think people have talked about that. One of my favorite is what I call the secret account number. I actually have an affidavit from a very big bank that they submitted to court, because we were questioning how the account number for what they were collecting, my client had never seen that account number, she had never had an account that, and we were told it's the secret account number, because once account gets charged off, they change the account number, and we can't tell you what the original account number is for privacy reasons. Now, I don't understand why you can't tell the alleged owner of the original account number. So there's no way for the consumer to match their account to this account because the account number is secret. And they actually did an affidavit that they submitted to the court that this is our practice. The account numbers are secret from the account holder. So how do you ever know if it's legitimate or not? One of the huge issues that we have a problem with, and I know we can't, the Bureau can't regulate what happens in the court per se, but I do think, just as they've done with mortgages, where we've said there's certain procedures you have to follow before you can file to foreclose, I think they can say there's certain things you need to do before you proceed to sue, such as making sure there's evidence that this is the right person and this is the right debt for that person. and that there's some way to substantiate ownership. We were talking briefly about disclosing on the statute of limitations. Well, my personal preference would be, as Paulina said, that you could never collect on a debt that's beyond the statute of limitations. At the very least, we should be sure that, I think that the proposals currently would have you be able to waive the reinstatement of the debt, revive, sorry. We do still have many consumers being told, pay me $5, good faith, just show it, not realizing they're reviving the statute of limitations. I worry about disclosures, written disclosures all over, because at some point you get so many disclosures that you're not disclosing anything because it goes over people's heads. So I think the act of even asking someone to do that should be considered deceptive, because really the only reason you're asking them to do that is to revive a debt that is no longer revivable. And I guess with deceased borrowers, from a consumer standpoint, what I'm very concerned about is the waiting period is fine, but if, again, you go back to that, if the widow doesn't owe the debt, they shouldn't be contacting her at all, right? And I say widows because it's usually widows that we deal with this, And so I think that in some sense, by the waiting period almost implies that after that's over, it's a free-for-all. So I guess it's going to depend on the careful wording of that. So these are just some of the issues that as a consumer advocate, I flagged, and I'm sure there's many more, but just to get the discussion going. Show of hand.
Thank you. Litigation, I think, is a slippery slope when it comes to debt collection, because remember that lawyers are state licensed. I get my bar from a particular state, and I follow particular rules of civil procedure. And there may be instances where the rules of civil procedure may conflict with federal law. There are many states, Pennsylvania is one of them, where they have FDCPA-type statutes. I think they're one of 18 where they have an FDCPA-type statute that applies to first parties, applies to creditors. So all the FDCPA requirements of harassment and abuse are there. However, the minute a complaint gets filed, or a pleading, or discovery, or settlement starts, those statutes exempt attorneys because that's when the states kick in. And I've been a believer that that is the appropriate way to do that. Because I think we are licensed, we have to answer to our judiciary. There's been a lot of case law out there that says, there was actually a case in Georgia, there was actually a case in Pennsylvania that went after an attorney for unfair trade practices, and they found that they could not do that because that was up to the judiciary, who are the supervisors of their license. So, as an attorney, not only do we have to apply to the laws of the state and federal government, but we also have our rules of professional conduct that we have to abide by, and one of them is we have to be a zealous advocate for our client. That gets a little muddled when we have to, also care about our adversary, and in this case, our adversary is consumers. So when we talk about statute of limitations disclosures, it's going to be very hard for attorneys. I would say if an attorney gives a statute of limitation disclosure to their adversary, in a way they have given their adversary a defense. That would technically be malpractice if you want to take it to the next step. So I think there's very, very blurred lines that we have to think about. Way of historical background. In 1977, when they enacted the FDCPA, attorneys were exempt. They were not included in the Act. In 1985, they were put back into the Act without changing any other aspect of the Act, treating attorneys exactly like debt collectors, which they're not. I mean, I would tell you that when we make a phone call or send a letter or communicate with a consumer before we file suit, absolutely have to comply with the FDCPA. But the minute we then, I think we can even argue when we're retained, there could be a difference, but putting that aside, consumers need to be treated in a certain way, and the FDCPA mandates that. But the minute a pleading is filed or we enter into the court, I would say that there are different circumstances there. So when we talk about litigation disclosures, that also, too, may present itself to be a problem, because there's usually a conversation going on with the attorney and their client about whether they want to sue. But as we all know, and we all have clients change their mind, things happen, people go into bankruptcy, they die, or maybe they decide, I just don't have the stomach to file a lawsuit. Things change. So I think it puts the attorney in somewhat of a difficult situation if those disclosures are mandated. I agree with Judith about the deceased borrowers. I think that has to.
I will say, we have seen a lot of abuse of the legal license by attorneys around the country in this area. A shocking amount of it from my standpoint.
And if I
I just wanted to make, I mean, sort of my counterpoint is the fact is that at this point in time, attorneys are covered. So I think it's fair for the Bureau to consider activities of an attorney, even if they're acting as an attorney in the act of litigation. So, I mean, obviously that's for them to decide, but it is in the black letter of the law right now.
And Josh has 2 cents to throw in just on his what's an interesting
just on
point
this-
and counterpoint. Yes.
Is it all right to jump in here
Pop
with a
in.
comment?
Yeah,
Please.
the next slide is questions, I think.
Yeah, I just want to say, I mean, a couple things on this. Certainly from our long experience, we've also observed a lot of abuse by attorneys using the courts to collect in a fraudulent manner. There is, and in fact, this is in this class action that the CFPB weighed in an amicus brief. It found that attorneys filing with the court false affidavits about a debt could potentially violate the FDCPA. But just coming back to a comment that Judith made in terms of thinking about the rulemaking going forward, even though it gets complicated once you get into the rules in the courts and it's state by state, certainly the CFPB should consider a strong rule that goes to what kind of account level information an attorney, or I should say a third-party debt buyer, must possess at the point of filing litigation, because we've seen over and over and over again that attorneys, and many of which are in joint ventures with the debt collector, so they're not, they're not operating really as independent attorneys, are filing false affidavits with the court and using the court system when in fact they're not having that information. So it's really, really critical. And I have to say, as an attorney, filing lawsuits, which in most other areas of the law, attorneys would never file lawsuits based on the information that a lot of these attorneys have that are filing for third-party debt buyers. It's pretty shocking as an attorney to see the lack of information that they have in filing lawsuits. So it's all to say that I think it's an area where a strong rule about documentation substantiation could go a long way, because a lot of the state courts are not like the New York courts. They are, it's sort of it can be an old boys network, and when an attorney who's coming in, every day into the court and filing papers, usually that's not questioned. And so without interfering in the state-by-state court process, the CFPB could go a long way in assuring that at least that attorney must have on hand the kind of information before filing a lawsuit that an attorney that files a lawsuit in any other area of the law would be expected to have.
Let me just comment on that for 1 second. I agree with you, and I think a lot of states have changed their laws, especially New York, as to what is the sufficient amount before filing a pleading, but there are still a lot of states out there that it's just notice pleading. So strong rules are going to be important for substantiation. I don't know if the Bureau is going to be able to dictate how pleadings are going to look or what information can be included in a pleading, certainly about what they should review before a lawsuit is filed. Maybe that, but I think that we get into the nitty-gritty of the pleading, that's going to be up to the states. And I think states are looking to New York, California, North Carolina, New Mexico. There's a ton of states right now where there has been changes in rules, where there has the requirement for substantiation even at the pleading stage has been there.
And I think that was my point, though, that the Bureau is not going to be able to regulate and shouldn't regulate, how many days after you file you do X, Y, or Z, the rules of proceeding. But they can, just like they've done with mortgages, regulate what happens before you file and what information you have and notices you give and that kind of thing.
Let me just thank you both for working on this presentation, putting this together, getting this conversation out there, really informative. Before I take a question, just want to thank you guys. Okay, so Chris, then Kathleen.
Yeah, I do want to, and I want to thank you for taking the time to turn it into a conversational piece instead of a presentation by presentation. I enjoyed this, the way you did that. Just a couple of quick things. One, on the time bar debt issue, that was another piece that North Carolina dealt with the debt buyer law. It was not just the substantiation, which was very important, but what it did was it it said that filing a lawsuit, it turned, sorry, I'm stumbling over this. Prior to the law, time bar debt, the time bar was a defense to the claim. They made it a bar to the claim. So basically, showed up at the courthouse and said, if it's time barred, don't even bring it. Recognizing that, and still, the vast majority of these cases end up with a default judgment. And so most of these folks aren't going into court with an attorney to be able to adjudicate their rights. And the reason for all of these protections, for having strong substantiation rules, for having it changed from it being a defense to the suit to having it be a bar to the suit, was recognizing that most of these folks are not going to be able to get representation to actually be able to effectively litigate their rights. And so the more we put in that requires people to have to be able to fight through that and show a court, hey, this wasn't reasonable or this didn't work, is going to make it more difficult. And the courts are looking for some of that same kind of certainty. They want to know what's a reasonable level of substantiation that we need to have. So certainly the courts in North Carolina looked to the statute and then worked to try to figure out how to implement that, but they wanted to be able to be pretty specific. The more that there's this sort of like, if this, then this, but then this, and then this, the courts sort of throw up their hands and say, you know what, we're going to have this real short baseline here, and then anything else we'll figure it out as we go along. Again, presuming that people are going to be able to actually go into court and make those arguments, and they're just not, because they just can't. They can't get the representation to do it.
Kathleen?
Sorry, if I could
I'm
just
sorry.
interject
Yes,
for one
please,
moment.
please.
Sorry. I didn't touch on this when we were talking about time bar debt, focusing instead on the disclosure, but one element of the proposal under consideration would actually ban suit or threats of suit on time bar debt, similar to the North Carolina statute.
That would be great.
Just thought I should mention that.
Thank you. Kathleen?
I have a couple of quick thoughts. One is that there's an article by a professor at Southern Methodist University, Mary Spector. Are you aware of it? Okay. She had her students go and look at the filings and saw exactly what the director was talking about. The other thing is, and this I know can be kind of tricky, and separation of powers issues and all of that, but the judiciary bears some responsibility here. I know in Massachusetts we have a huge problem where the clerks are just entering the default judgments when people don't show up, and there isn't adequate documentation in the materials to support any kind of judgment. And I don't know if this is a place where CFPB could, once the new rules are out, sort of do presentations at judicial conferences, just thinking that the judges might want to know what, what the new regs are as a way of sort of goosing them, that they need to make sure that before they're entering default judgments, so that the attorneys have complied with the law.
We have done some of that. We could do more. Your old friend, former CAB member, Judge Rizzo, is eager to help us with that. And we've had discussions with the states in terms of some of the reforms that they have developed that I think have been informative. Let me just say, just as a general principle lying behind this whole project that our team's embarked on, and I think it's implicit in what both of you had to say about the background of your presentation. One of the flaws in the FDCPA was that for 40 years, there was a sort of hardwired statutory set of provisions where all the further development and nuance around those provisions had to be developed through litigation in courts, and really could hardly be done anywhere else except sometimes where the FTC could. Actually, they did a fair amount. But what that inevitably means is you're going to have a lot of issues that are tough issues, close issues, where different courts are going to decide things differently, and suddenly there's kind of a mess on your hands in terms of what guidance do you give to clients. When I was a Ohio Attorney General, it's always the worst situations where courts were now in disagreement, and it's going to take a while for that to resolve itself, and it's very hard to describe what the right answer should be in the meantime. And the whole premise of doing a rulemaking is that we should be able to nail down with specificity a lot of those things so that it at least now is going to be clear. And it's going to be one way rather than another, and everyone will know it. Now, whether we'll get those answers right is another big question. Everybody always says they'd rather have an answer either way, but sometimes they don't really mean it. So we'll work on that and figure that out. But if I'm hearing, and I'm hearing it echoed in your comments here, if we deal with a lot of these issues with mushiness and not specificity, we're not necessarily advancing the ball much beyond where it may be now on those issues. So for us to push through to get to more definitive answers is part of the whole reason to be doing this. Now, again, degrees of confidence around those right answers are always a hard thing to work through, but I think we're recognizing that to some degree, and the fact that you see the outline of proposals for the SBREFA, that is by definition a less specific document because it's more preliminary. But by the time we finish with this, we should be much more specific and clear if it's going to succeed in part of the aim.
Other questions, comments? I wanted to circle back, actually. Oh, sorry, who did I miss?
I'm feeling
Sorry,
a need to get her in the
Chi-Chi.
conversation because I knocked her out early. So, yes.
Thank you, Director. I just thought, I wasn't actually planning to speak in, but since Judith raised my name with respect to the IRS issue, I thought I'd throw it out there because I think this will be an important trend. The legislation of all things, the highway bill from last December, not only allows, but mandates that IRS place all inactive tax receivables, which is defined in the statute as basically anything older than 3 years if an IRS collector is not assigned to it or if there hasn't been a contact for over a year, mandates those debts be placed with private collectors. That's a huge number of accounts. Those private collectors, one of the ones selected by IRS had been fired by the Department of Education for lying to borrowers. So we have some concerns about how this is going to be implemented. About 79% of the borrowers, according to IRS data, are going to be under 250% of federal poverty. And if you think about it, these collectors are going to be calling consumers. I bet if we took a survey in this room, at least a third of the people had gotten those scam calls where they said, this is the IRS and you owe us money and please go down to Western Union. Well, now you're going to have real collectors calling about IRS debt, and this is just going to increase the confusion and difficulty out there. And
Chi-Chi, this is after I've told everyone the IRS never calls you.
and after the FTC.
Is it clear that they will be calling? Maybe they'll be writing letters. I mean, that may not be clear yet.
No, they'll be calling and using cell phones.
Yes, and they're allowed to robocall under the law, and we actually asked the IRS not to allow robocalls, not just phone calls, just robocalls, and they gave us a big fat no.
Let me ask a different question, and I've been asking about it internally. So I have some background in debt collection myself. I was a county treasurer. We went to collect delinquent property taxes, and we were working with businesses. I was aggravated by businesses that had not paid their property tax. That didn't feel right to me. And so I didn't know much about debt collection back then, know a bit more now. And, you know, we were the government, so we weren't necessarily constrained by all of this law. But what we sort of understood as a sort of homely matter of principle was if we were going to threaten to do things to collect debt, we needed to follow through on it. So we came up, everything we could think of to do, we would do, and then we would follow through on it. So we would tell them we were going to contact the Better Business Bureau if they didn't pay their debts. Some of them paid, others didn't. We would tell the Better Business Bureau that would be whatever it be. We said we were going to let Dun & Bradstreet know that they weren't paying their debts. Some of them paid because that mattered to them. Others didn't. We would follow through. We said we were going to tell all the local banks, et cetera. One of the things that I find that debt collectors will do is if they have an option to do something to people that people might care about, they will then tell them they're going to do that, and that will be a mechanism for leveraging collection, and there's nothing wrong with that. So they'll threaten that they're going to bring suit against you, or they'll threaten they're going to report it to the credit bureaus. One of the things I'm not clear on is there seems to be a further threat that lies behind all of this, I'm now understanding, which is that if you still have a debt that they think you owe, and they're no longer going to collect on it, they could potentially tell you, and maybe they're correct, that they will have an obligation to report it to the IRS on a 1099, and you will then get a tax bill on that debt. Is that correct? Are they required to do that with the IRS, to report a 1099? And under what circumstances, if anybody knows offhand?
Yeah, if it's over 600, I mean, so if a debt is uncollectible, or the client doesn't choose to collect anymore, there's no more communication. If it's over $600, the debt's forgiven, and there could be there could be a 1099 issued to that debt collector.
What do you mean could be? Are they required to do it?
It's up to the creditor to make the decision. The credit, it's because it's not, for a third-party debt collector, it's not their debt. They don't issue the 1099. It would be up to the creditor to make that decision.
So they'd have to push it back to the, so but a debt buyer would be the creditor.
Right, and then a debt buyer, they would ultimately make the decision.
So won't debt collectors use this as a collection mechanism? Won't they
Well, it's
always
interesting
wanna
that you say
they're
that. Now,
gonna do it?
maybe Citi and Discover and some of the other banks that are here might disagree with me, but for my clients, from my clients who represent financial institutions, they're making them say that in the letters. I don't think it's actually, personally, I don't think it's a great idea. Because
And they're making, who's making who?
the creditors are making the third-party debt collectors put that in their letters. I have had fights with my clients to say, don't do that. They're like, no, that's what the client tells me to do, because it's not their decision to make. It's the creditor's decision to make, whether they're going to, if they
But
get a bunch of.
if the creditor's telling them to put that in the letters, the creditor's making that decision, aren't they?
I don't know whether they're ultimately doing it or not. I don't know. They're saying that's what they want to do, but I don't know when the account goes back, that's what the creditor's going to do. I can't confirm that.
Oh, so you're saying the debt collector is telling you that the creditor is telling them to put it in their letters, but you're not sure the debt collector is accurate on that?
I'm not sure that the creditor is accurate, that when the account comes back, that they'll ultimately issue the 1099.
Oh, so that, I see.
Do you understand what I'm saying?
Can I just add that an additional problem there is that, and we're seeing this in mortgages quite a bit, issuing the 1099 doesn't mean that they can't continue to collect. So we'll have somebody who got a 1099, I actually have somebody like this, you get a 1099, you declare the forgiveness of debt, you do the whole tax thing, and then a year later it's been sold to a debt buyer, so it's no longer forgiven, and then the burden's on the consumer to go back and do an amended return. So, I mean, again, I don't know if there's any authority here to do this.
That's quite pathetic.
It's very pathetic. But I mean, to me, they shouldn't be able to issue the 1099 unless, in fact, they're forgiving this debt and it's gone. But that is not what happens.
I'll tell you what's interesting, Director, is there's been cases where the language has been in that letter and it's found to be a violation of the FDCPA. There was a recent case where the language wasn't in the letter, and the court found that that was deceptive because the debt collector should have said that possibly it could have been.
So I'm just
right.
What's occurring to me is that you can have debt that is beyond the statute of limitations, beyond the ability to report it or have it stay on your credit report, and yet you still, as a debt collector, you would have one more mechanism of leverage over the consumer that sounds quite severe. We're going to report it to the IRS, and they will make you pay tax on this, which if your bracket is 30%, then you might well be persuaded to pay 20% on the debt to settle it. And so they have one more round of getting at you beyond all the rest of those protections that supposedly we're going to kick in. That feels off to me. So anyway, maybe you can help us think more about that.
And just related to that issue, now that you brought it up, I'm seeing more and more 1099s, which I do think is a change. And they're not, and there's a real problem with the accuracy and a bigger problem with getting it corrected when it's not. So, that is really becoming a problem. And as I said, the ones I'm seeing are mostly related to mortgages, but I'm seeing actually more.
You can just imagine the nightmare. So the creditor then reports it to the IRS. They've tacked some extra fees on just for the heck of it. They're aggravated by that former customer anyway. Now the IRS has a number. In order to fix that, now you've got a triangle conversation that has to go on, and I can't imagine it's a very easy conversation because the IRS, their budget's been cut. They can't answer their phone these days. I mean, that just sounds
Well, but it
awful.
also, the original creditor's response, because I've had these conversations, the original creditor's response is, well, we charged that off. We don't have any documents. When you try to find out, wait a minute, the number I have is this, and the number you're reporting is this. The original creditor's response is, well, we charged it off. We don't have any, which goes back to, again, my point that there should be some record from the charge-off.
I have a technology-based collections tool that's being used that seems to be problematic, which is remotely created checks. So something that I think was intended perhaps to facilitate collections in a positive way, perhaps for both the consumer and the collections entity. We are working something, we have learned that what happens can be that that a remotely created check can go ahead and pass through somebody's bank account, and it's hard for the bank to even identify that this is coming from an entity that is, who is no longer authorized to collect, because the way that it's coded when it hits the bank, it's impossible to identify it as being, they would have to look at what's coming through, apparently pull things up one by one, which they're loath to do. The other problem we're finding is, as we've drilling down in a particular case, is that everybody's disclaiming responsibility for having issued the RCC. This is a mortgage servicing case. So homeowner originally gave permission to go ahead and make electronic withdrawals from the account, canceled that permission, and then was making payments on his own, made payments, and then got hit with the RCC repeatedly, even though he actually was up to date. So double payments basically happening. He's paying, and then the RCC was hitting. Servicer is saying, we didn't do it. We have no idea where that came from. How is that possible? So we're still learning about this, but when we think about technology and collections, I think about the, again, tracking and accountability for the all people in the chain of collections, including the consumer's bank, to be able to have easily identify who in the heck it is that's trying to access the account. This seems to be fundamentally problematic. Sorry, John, go ahead.
And Maeve, are you being purposeful in excluding ACHs?
Yes.
Thanks.
So I have a different question, because the RCC, remotely created check, has come up in different contexts for us a couple times in the last couple of years. And I have a question for the bankers in this room, if you know. Is there any current purpose really served by remotely created checks? Are they an outmoded item that doesn't really, is there any reason for remotely created checks to be sanctioned and to continue to exist? Anybody?
We'll find out.
Okay. I'm not clear that there is. But the one thing I've seen is that, remotely created checks are reserved as an option by entities that want to get you to agree to pay through automatic withdrawals electronically, and they are aware that they can't, under the EFTA, require you to do that as a condition of extending credit. But they say that because they have the remotely created check as the alternative, that makes them gives them the argument they aren't actually requiring you to do this because there's options here. But it's not clear to me it's really a meaningful option, or it feels like a vestige of a bygone era.
I see Neil and then Jim.
Rather like earlier, I was
okay,
thinking that the educational credit score may be a vestige of the bygone era too. I'd like to hear more about that from any of you who know.
Okay, sorry, Neil's forgoing. Yeah? You
Yeah, other than, I don't understand where, I can't think of a purpose right now that would be a commercial purpose that would make any sense.
Helpful to.
Did at one time, but perhaps not anymore, yeah.
And I'll also check to see, I mean, there was a question around the ability to actually track what was coming through, who was doing it, and surely we can. So I'll check on that as well.
Interesting, thank you.
Let me just give my point of view on that. I do quite a bit of advisory work for one of the vendors in the check kind of conversion or check electronification space. It's actually quite a big market. So I would respectfully give a counter view, which is I think I could quite imagine quite a few scenarios under which that would be useful, because unique to the U.S., maybe, and we have so many, we're way behind in the U.S. in electronic payments. And so sometimes there is great difficulty in simply getting money from one willing payor to another payee today. And so, but at the same token, a paper check is not always convenient. So I could imagine a lot of scenarios in which you want to have an electronic document that has all the routing information of a paper check, but it's just an electronic form. I know several cases where those are used today because people can simply say, look, use this. It's a simply it's like the equivalent of a template, but it looks like a check, and then you just fill in the spaces, but then it has everything recognizable to both parties. And it does bring up that issue, though, that you started out with, Maeve, which is if you don't attach the memo information in there or somebody doesn't read it, then the whole system goes haywire. But the point is that there are a number of use cases, and it's really not dissimilar to what goes on in a Walmart today, for example. Call it check conversion, and where somebody walks in, pays with a paper check, and the person says, okay, I'm going to just convert this and
That doesn't sound like the same thing as a remotely created check, though, does it? I thought a remotely created check would be something that could be created without your involvement, as opposed to what I think you're talking about is, and I see this sometimes with some of my bills, you write a check to someone, they convert it to an electronic payment, and then it's cashed in that manner.
I was using an analogy there, but my sense was that it was, unless I could be misunderstanding you, but my sense was that somebody was issuing essentially a template, and somebody on the other end would fill out that template, ordering the money to come out of your account, ACH-like. No?
Different
Okay,
thing,
sorry.
yeah.
Which leads to another thought I have and a question I have when we think about making debt collection a little more fair, and it is just transparency. If what this mortgage servicer is telling us is true, there's another vendor in the mix. And we've been being told there's another vendor in the mix, but they won't disclose the name. So if you don't know who the players are, how can you correct the problem? I mean, and that's how you end. That's just you end up exacerbating the situation. And I have a highly sophisticated client who's documented the heck out of everything, where we've actually had genteel conversations, which we always do before we go to court, and said, can we fix this? We're sure this is a mistake. This consumer tried to fix this. So that raises more questions for me also about the ability on the back end of the collections operation to actually control what's going on. Because you've got intentionality sometimes, but then you also have just lack of oversight, inability to control your vendor. More questions about, at some point, a little more transparency if you're going to outsource the collections function. So not just even the documentation, but who the parties are who are actually involved in the transaction. Other comment? Yeah, Judy.
I mean, one of the things, and I didn't go into it in a lot of detail because I wanted to see where the conversation was going, but when we were talking about sort of having a chain of title, that's one of the concerns I think we have in the debt collection is because there is no transparency. So you as a consumer have no idea where in this chain your debt is. And, you know, I'm not going to say it's the common thing to happen, but it has happened where, I'll give you an example of my client. You know, you have two people collecting on the same debt. So it is common, if you're representing the kind of clients I do, for the client to come in with a paper bag full of stuff. And I have a client who just did that, full of stuff, right? So we've got multiple medical bills, multiple debt collectors collecting the same medical bill. Now, probably one of them is no longer collecting it, right? It's been sold to the other. But all the client can see and all we can see is, okay, well, these all look like the same. And then you try to get validations from everybody, which is incredibly time-consuming and silly, and you sometimes get responses and you sometimes don't. In my experience, when a validation goes out from a legal aid office, I would say more than 80% of the time, they just don't respond to me. And I think logically they're thinking, we're not going to get any money. Forget it. But so here I am with my client's paper bag full of stuff. He actually would like to pay on some of these, believe it or not. We don't even know who to pay because there's no chain of title. You don't know where it is now.
I think you also told us that you then keep all these files even after, so you must have multiple storage units that you rent, I assume.
Thank you. Okay. I see Josh and Chris.
Yeah, just very briefly on the chain of title, just to point out that in the New York State rules, in the court rules, a chain of title affidavit is required in order to secure a default judgment, and also under the New York State rules, the Department of Financial Services, when somebody is seeking to verify a debt, is challenging the validity of a debt, the debt buyer has to provide a chain of title information. So just a couple of models maybe to look at in thinking this through.
Thank you. Oh, Chris.
So this may both be a question of what information should the consumer have and what action should the sort of original, and in this case, it was a medical issue, but just a couple of examples to think about that popped in my head as we thought about this. One is I had a family member who went to a medical clinic and was sent two bills, one for the exact same amount. One was for the doctor's office and one was for the hospital. And they both had identical charges, but they were separate charges. You pay one because you think, well, you must have been sending me two bills for the same amount. Turns out that the other one, that you owed the other one, it gets sent to collections and you're told you owe $35. And of course you say, no, I don't, because I paid that $35, but it wasn't that $35, it was the other $35 you had to pay. So trying to figure out how you explain that to, I wish that were routine, but oftentimes there are identical charges for the same medical procedure that are charged by two different entities with the same name. And how do you differentiate between the two? The other was a series of cases that we got turned on to. One lender, a car lender, sold their portfolio of car loans to a second lender. The second lender realized that the first lender had foregone late fees. When people would pay late, they would just say, you know what, we're going to give you a break on this, just pay us when you can. The second lender went back, recalculated the loan, said we under the contract, we're allowed to charge you the late fees. And so they went back, recast the loans, and then sent them a bill saying you owe us somewhere in the neighborhood, usually between $600 and $1,000, so just small enough that no attorney would take the case, but big enough that you can make some money on it. The difficulty, and we talked with the Attorney General's office in North Carolina about it, the difficulty is that most of these folks were paying by money order. And so unless you had somebody who was keeping very consistent records of the money orders that they were sending, which most people weren't, that sort of proof of payment, that ability for them to say this isn't right, was very difficult. And the other piece was that what they were getting was just a spreadsheet that anybody could have created saying this is the amount that you owe. Certainly there would be pleadings and things like that, but I think in thinking about how people will defend themselves on these issues is thinking about how most people, in some cases make these payments, and it's not always through their bank account where it's easy enough for them to be able to go back in and look at their account statements and see, yes, I made these payments on time every time. They had one lady who did. She kept every single stub of every single money order, but they had 75 other cases where they weren't able to do much because fault on the person for not keeping, every single stub of every single payment that they made, but, certainly creates.
Move a few times in their life? It gets.
5-year car, and these were, some of these were coming after they had paid off the loan, and coming back and saying, you still owe us money. So it could have been 7 years after that initial purchase, which at that time you think, I'm done, I've paid it off, I've got the title, I don't need to keep this anymore.
The woman who kept the receipts was Judy's sister.
I actually did have a client who had a mortgage collection, and he came in with 15 years of checks to prove that he'd made every single payment. It's rare.
That is rare, Judy. Other questions or observations on our broad range of ground that we've covered here in debt collection? Yes. I have a question about the privacy issue. That's just bothering me. And I'm not sure who the right person is to ask this question of. I think I'm hearing that the privacy concern ends when the first-party creditor sells somebody's information to a third-party debt collector, but that there's a privacy issue as long as the first-party creditor has contracted with somebody to engage in loss mitigation. Did I totally misunderstand this? And because I heard from you, Will, about a privacy issue and in the collection space, and so that I still have not quite wrapped my head around and truly want to understand, because I know I don't know all of the.
But what privacy issue?
Well, that's still my question.
What are you talking about?
Well, this came up when I was asking about a question about this afternoon about why it is that you can talk to one set of mortgage servicing staff and have them tell you that they can only see limited information in one set of screens. I call one number and I'm told I can only see X, I can't do these other things for your client, so I can't even offer these other options. You'll have to talk to somebody else. I call another number for supposedly the same creditor, call this number. Okay, I call it. Oh, this other person can see more screens. I was asking earlier about my concern about people not being given full access to loss mitigation options to the extent that they exist, and questions whether there were structural problems in the way in which the collections is set up. And I think I understood from Will that
I think
they
the
were
que-
set up that
yeah.
way for
Well,
privacy reasons?
I think the question was also internal versus external, so.
Yes,
Who's seeing
yes.
first party, who's seeing secondary, and obviously there's going to
Okay.
be different degrees of information that someone who works for the bank is going to have versus not. As far as the different, I've actually sent a note after the conversation a second ago to someone within Mortgage Ops to get a clear understanding around why that would be internally, to answer that question first, because I don't understand that as well, within the bank, why you'd have two different sets. Of course, I'm still trying to figure out who the secret number is. So let me check on that as far as what we would give to someone, from a third-party standpoint versus internal. I mean, you obviously know why there would be different screens that would be seen.
Could I ask on to that? I mean, and maybe I'm misunderstanding it. To me, those privacy issues should end if you've sold the account, right? Because if you sold the account, then you're the first party creditor. You've sold the account, so there shouldn't be any privacy reasons that you can't send all the information with it. I mean, am I?
That's a different issue, different question from mine. Mine is about getting full access to loss mitigation options, and I see Neil with two fingers up in the air saying, ask me, I know the answer. Yes.
Well, I'm not sure I know the answer, but maybe what you're suggesting is that in the same institution, you're getting somebody saying that there's one person that can handle it and another. This is something, particularly during the heyday of the mortgage servicing crisis, I did see a lot of. Some of it is just, frankly, internal process breakdown. But to Will's point, I think that what you also have is you've got certain functions, and the way I describe mortgage servicing into collections, it's kind of like a handoff. And I'm not apologizing for it or rationalizing it, just the way it is. And I think that what happens is that you've got certain functions in that chain that have more access to customer information for purposes of security and privacy than others. Okay, in other words, so it's not like anybody who picks up the phone can have full access to all your records for your own protection. So I would say that I don't think that there's any legal thing. I think it's more, frankly, probably something that you ran into in terms of an internal protocol or process that may or may not be efficient. But I've seen it a lot in terms of customer complaints that we did get during that period of time, where there were people,
I have massively, and it's been 11 years.
Yeah.
It's been 11 years of the same stuff. And so it does seem to be a fundamental, thank you so much for your response with it. It seems to suggest, the reason why I'm raising it is because we talked about loss mitigation versus collections. If you have, and we talked about it, and it's more, in some ways, it's very compelling, certainly in the student loan context. We talked about people being able to make that phone call and being told, pay this money, whether you qualify for a discharge or not. And so I'm going back to the mortgage context that I personally know better. My staff work on student loans a great deal. I have not. But to highlight the question of how much loss mitigation issues should be a concern when the Bureau is looking at collections. Because if collections is about not lying to somebody, but just straight up saying, you owe this, this is where you racked up the debt, this is how much you owe, here's why, then shouldn't options related to loss mitigation, and I think that was built into your presentation, Kristen, when you were talking, is about at least having general information that would go out to the consumer possibly, as a possibility, saying you might have loss mitigation options, or did I miss?
We are not looking specifically at loss mitigation, since that's subject to a number of other regulations.
Okay, and I'm using loss mitigation as a term to, basically I mean I should say ways of.
Negotiating payments.
Negotiating payments, right.
Okay.
But
Payment options.
But,
Point, I don't know if somebody's trying. You know, unfortunately, we're talking about semantics, but the way the mortgage servicing rules work after gotten through is important. And maybe we can, to whoever may have said it, how can we learn from that? So what should be the, you want to call it loss mitigation, you want to call it payment plan? Should there be, especially in the student loan space, should there be times in that process where there is a way to look at what your loss mitigation are, and that should be mandated? Right now, there isn't, and it's too fragmented for the industry to know.
And we're talking, and payment plan, and it is semantics, but the words matter. So I will say, to tag on to that, modification of the loan is really what you're talking about, whether it's in the mortgage context or student loan context, where you're changing the interest rate or payment amount due, yada, yada. So yeah, I think maybe there's something to be drawn from that that's appropriate for the work that you're doing. I saw Kathleen and then Raul.
I'm not understanding that. I would have thought that a debt collector always is given some set of instructions about what their latitude is in terms of payment options, and often I would assume they have a lot of latitude. Is that, and then they follow that, but isn't that part of the conversation? I don't quite understand how this is being separated.
One of the problems we've had with, I think it's particularly HUD loans, that were sold off, right? So the contract gives you certain loss mitigation rights, but the buyers of those are now claiming that because we bought them, you no longer have those rights. So I think this is one of the things we're concerned about. If you've got certain contractual rights under your mortgage contract, under your student loan, whatever, if it gets sold to a debt buyer, those rights need to continue. And we have seen that with some of the loans that have been sold off, where the debt buyer is claiming, no, there are no rules because now it's ours and we get to do whatever we want. So I do think that there needs to be some consistency as we go down the line.
If I could just add to that quickly, I do think there's, and the comment was made earlier, that it is not just semantics. I think intentions can also be very different. And I know right now we're talking about third-party collections, but you've also, and this has been beneficial, I think, to hear you signal that eventually you're going to move towards first-party collections. The behaviors are very different. The incentives are very different, right? For us, it's not just a question of payment plans. It is truly trying to mitigate a loss. It is trying to contact someone to understand, did something happen? Max did a very nice job, I think, earlier today articulating the way to think about what can happen during the life cycle. And even as you think about number of times that someone can be contacted, we try to reach someone just to understand what happened. And depending on what happened, there are different things that we can do. So I only bring that up because I know right now we're having a conversation in the context of third-party collections, but given your signaling of first-party, I do think the language matters, but I think more importantly, the intentions of a particular party can differ greatly. If you're a third party, that in some cases, especially if you've bought the debt, as has been pointed out, there's not an element of brand involved. For a first-party company that is doing their own collections, brand matters a lot. The relationship with the customer matters a lot. So I only want to bring that up because I'm very cognizant of the fact that this is probably informing your thinking about what you might want to do later. And as Joanne mentioned, I'd certainly ask you to involve as many as you think make sense, first-party collectors, so that you can get that perspective as well.
Thanks, Raul. Kathleen, do you still have a comment?
It's really a question. The problem that you described, Mava Elise, I've seen as well, and I think most people here have. But could the distinction be between servicing loans that are held in portfolio and servicing loans as a servicer who is contracted with an investment bank as part of a securitization deal to service? I guess that's really a question for the bankers. And I'm referring now to the inability to access full information.
My understanding is under the statute, it can vary depending on whether the loans are placed with a collector before they default or go into whatever the verbiage is, or after, even though they may then go into that even while they're with the collector. It feels a little bit arbitrary to me, and some of the definitions that aren't entirely clear to me, although John and Kristen have a better sense of it.
Okay, Ruhi, you're going to close us out.
So,
Last comment.
Judy, I'll give you a much longer answer to your question, but there were certain HUD rules when they first sold their distressed asset portfolio. I, along with a whole bunch of other folks, really pushed, and the rules changed. So it depends on when the loan was sold. And then FHFA has changed placed additional requirements, and I actually did a presentation on that. I have information on that. We probably have a webinar on that as well. So it is very, very confusing, and I've tried to talk to the attorneys who are collecting and try to make them understand. But if you think they're violating the rules, and I can give you all the information, there's a whole bunch of us working on this, and we're taking it back, and we're definitely documenting it because we know that they aren't following the rules. They got the loans at a discount, and they're essentially, trying to kick the folks out and, make money on the purchase when the point was to stabilize the community and the loan.
Maeve, could I just say, the reason I brought that up, though, is I think when you're making rules, one of the things that needs to be clear is that selling the debt to a third party does not change the loss mitigation options that were in a contract. It's still the same contract. And so, to me, if you try to change that, that should be a violation. If you're trying to say, hey, your contract says you've got X, Y, and Z rights, now we just gave it to somebody else, you don't have those rights anymore. As a third party, I shouldn't be able to negotiate away Joanne's contract rights just because I sold it to Maeve.
Gets very complex with the distressed asset program, actually. A whole different ball of wax, but we can talk about that. Thank you so much for your energy, your focus. Thank you to the public. Thank you very much to the director and the staff, John, Kristen, Alicia, for your time and the great energy of CAB members. This concludes the public part of our meeting today. Thank you again for your time and engagement. Have a great rest of the day.